I think we need to defend religious freedom because it is eroding. The guarantee of free exercise of religion seems to be weakening in public esteem.
The first I heard of the case was when I got an email from this attorney, and basically the email said, look, you have a direct violation of Title VII for retaliation. Our client has threatened to sue. At the time, I was doing small work for the church, such as help them maybe with a contract for somebody that was cleaning, but I certainly wasn't involved in any litigation. So when I got the call, first of all, I was terrified. Let me call and find out what's going on. I'm attorney Deano Ware. I have a small practice in Redford, Michigan. My name had been given to him as the church's attorney, but that was kind of a loose phrase at the time. I wasn't getting paid. I wasn't part of the board or any of that. My kids went to the school, and I was a member of the church. I actually told some of the other elders at the time, look, we need to start interviewing larger law firms to start dealing with this. And they told me, we can't afford to hire a law firm. Well, this is a serious issue. I said, and I don't do this kind of stuff generally, but let me see how far I can take you guys. So I was shocked when I got a complaint by the EEOC. The EEOC literally took her case and sued our small church. They saw me as a small attorney. They knew I didn't do this. They could look me up on the internet. We had already went well beyond what we were required to do in our employee manual as far as leaving her on the job. It became obvious, however, that they weren't interested in simply bringing her back to work. They wanted to hurt the church. That's when I realized that there was not going to be any compromise if it involved hurting my church. If you've ever seen a deer in the headlights, I was a deer in the headlights at the Sixth Circuit. I had never done an oral argument like that before. As I started to do more research on the case, I came across this thing called the ministerial exception. And I had never heard of a ministerial exception. So that if you are a minister of a church, in whatever capacity you're serving, the ministerial exception recognized the right of the church to exempt you from certain Title VII requirements as a minister. And at one point it got to the position where the court said, well, what if we find she's not your minister? So we gave her a call. She accepted the call. And now you as a court are going to say, what if we find she was not a minister? I said, then we should lose. And we lost the case. We lost the case. When I got that back from the Sixth Circuit, I said, well, Lord, I don't know what else I can do. You have to understand that up until that point, I had litigated this case literally by myself. And I was not just litigating against her attorney, but I was litigating against her attorney and the EEOC. And they were engaging in tactics that I would say were intentionally designed to try and break me. Now, throughout all of this, you have to realize I've only been out of law school probably 3 years. My office then was pretty much what my office is now, just a small office, and I'm trying to practice as far as supporting my family, but at the same time, I'm trying to defend the church. I never got paid a dime, but throughout this, I'm working on the case, and I'm spending late hours at my office because I'm trying to go out in the daytime and actually earn a living. But then in the afternoons and the evenings, I had to go learn civil rights law. So I had to go read up and study up on the Title VII cases, and then I would get scheduled with depositions. So it was a lot of pressure, and we hadn't even done a trial yet. Some of these trials can go weeks, right? And that would have ended my practice, because I just it got to a point where I wasn't able to pay the bills, but I was not going to abandon the church. I was not going to simply walk away from the case. So, I was kind of maybe one strike from being knocked out. And I say this with all truth and sincerity, I knew that God was going to help me. The Sixth Circuit, in their opinion, said, well, you can try this case without bringing faith into it. But there was not going to be a trial without faith coming into it. Shortly after the case got reversed, I got a call from the Becket Fund. And it was just very simple. He said, you know, we heard about your case. And he said, we want to help you. And that meant a lot to me. But I ain't got no help at that point. And I remember getting on my knees and praying. And I thank God.
The Becket Fund got involved in the Hosanna-Tabor case because it was such an important legal principle that was involved in that case. But the Supreme Court had not yet held in a case that the ministerial exception protects this special relationship between churches and its ministers.
And I remember catching the train to D.C. because the Becket Fund had invited me to come if I could make it up there. They got me a seat inside the chamber. I had $50 in my pocket. I think I had like $100 on a credit card. So I got to the hotel room and I didn't realize I guess hotels up there, they hold like $100 above and beyond what you pay for the room. So I was like, I had like $50. I mean, luckily I was only up there for like a day and a half, but I mean, it was true. I had like $50 in my pocket. And I remember telling the Lord, I said, well, Lord, if we win this case, wherever I'm at, I'm just gonna drop to my knees and pray. And I don't care what people think about me or where I'm at. And it's like I said, luckily I was in my office when I got the word that we had won the case, but I did do that.
The Wall Street Journal actually called the Hosanna-Tabor case one of the most significant religious liberty decisions in the last half century. And I think they said that because it's such an important reaffirmation of this very special relationship that a church has with its ministers. And the opinion said, you know, the government just has no place intruding in that very special relationship between a church and its ministers.
The United States Supreme Court's remarkable decision in the Hosanna-Tabor case. Remarkable for its ruling, its opinion, and its unanimity. We salute all involved in advocating this marvelous precedent, which we pray will be applied rigorously and persuasively for years to come.
You know, a lot of times people think you need to be high up to be used, but God found me where I was at. And sometimes, you know what, that's all you can do, is make yourself available. You don't know how you're gonna do it, how you're gonna litigate it, how you're gonna strategize it, but sometimes if you can just not turn it down, don't say no. You leave the door open, in my belief anyway, for God to work. Because the Lord has access to things you do not.
I would tell every attorney that is religious in their nature that they should be sensitive and look for opportunities where they can use their professional training, their professional experience, and their religious training and experience to help protect religious freedom.
You know, I would encourage everyone, no matter where they are, no matter what station of life they're in, no matter their educational background, to educate themselves on the issues in the defense of religious liberty. They need to know why it's so important, what the challenges are, and to become aware of the local issues in their own neighborhoods, in their own communities, in their own cities. When those issues come up, they're there, they're ready, and they're able to respond in an informative way.
They can do that through op-eds. They can do it by giving talks at Kiwanis Club. They can do it at the auxiliaries of any of their churches. They can teach. They have that experience. They can teach the principles of religious freedom throughout the country.
Religious leaders and believers must unite to strengthen our freedom to teach what we have in common, as well as to teach and exercise our very real religious differences. We must walk shoulder to shoulder on the same path in order to secure our freedom. We must also insist on our constitutional right to exercise our beliefs and to voice our conscience on issues in the public square and in the halls of justice. These are the rights of all citizens, including religious believers, leaders, and organizations.
I think what the case actually has stood for is that religious liberty and religious freedom is not dead in America. That these are still issues that courts are not only willing to take seriously, but they're willing to defend. And that gave me hope. It gave me real hope. To have that unanimous decision, that basically told religious organizations and entities throughout the country is that, if this is an issue that you hold dear, fight for it. Fight for it.